What is up, guys? Welcome back. We're going to talk about Karen Reed here. Those of you guys that are coming over from Delphi. Well, Bev denies the motion. I was expecting her to deny it, but us taking a look at her order gives us a better idea of where her head is. So that's what we're going to do. Those of you guys coming over from the Delphi Live, yes, Richard Allen's defense fund keeps growing. We're going to keep helping it grow. I have 2 more lives scheduled to do like fundraiser type things for it. So anybody that is sharing that, donating to it, you guys rock. Thank you. Again, hello, members, subscribers. Let's talk about some Karen Reed. Good old Beverly. Again, she denies the motion to dismiss. They were in the courtroom 2 days ago on the 26th, and it was strategic that they did not file. They were going to file some more motions, but they held back, and they said it was strategic. Alan Jackson wasn't there. He was there, but he was there via Zoom. Bev wasn't having that. Yanetti's, I believe it's his wife was there with Karen Reed. He was not there. But they said it was strategic that they did not file additional stuff they were planning on filing. Now, let's take a look at jumping right into oh boy. You guys realize that up here on the right, 255 is the number, like that's the 255th filing, whether it's an order, whether it's a motion, communications with the court. So, is it his sister? I knew it was fam. So again, I think that this helps us get an idea of where her head is when she's going to be considering things. So those of you guys that are following the Karen Reed case, again, this is another case that, wow, corruption, yes or no, kind of like Richard Allen, kind of like Idaho. What do we think? So again, when Karen Reed, so on June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of murder in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe. And this stemmed from an incident going on January 28th, leading into the 29th. The defendant is pursuing a third-party culprit defense, arguing that one or more persons attending a social gathering at the home of Boston police officer Brian Albert on January 29, 2022, killed O'Keefe, and that they, along with others, including the Canton and State Police, engaged in a cover-up of the crime. Okay, that's your summary of what's up. Now, the defendant now moves to dismiss the indictments against her on the grounds that the Commonwealth's presentation of evidence impaired the integrity of the grand jury proceedings. See Commonwealth versus Odell. This is why they were always referencing that with all of their oral motions when we saw them oral arguing. She argues that the Commonwealth knowingly and recklessly presented false and deceptive evidence to the grand jury and withheld exculpatory evidence for the purpose of obtaining the indictments. Okay. Now, the defendant also argues that the Commonwealth deliberately admitted inadmissible evidence to secure the indictment. So, deliberately inadmissible evidence to secure the indictments. On March 12, 2024, the court conducted a non-evidentiary hearing on the defendant's motion to dismiss. This is when they were all in court. The court has carefully reviewed all the grand jury minutes and considered each of the defendant's arguments. Oh, God. Given the extensive evidence supporting the indictments, this thing. Sorry, my phone going crazy. Given the extensive evidence supporting the indictments to the extent that the Commonwealth improperly put before or withheld any evidence from the grand jury, it is unlikely that it affected the outcome of the proceedings. Accordingly, the defendant's motion is denied. So it's denied. Here's now the background, and this is important if you want to understand. This trial is just 3 weeks. When is it? Yeah. 3 weeks away, not even. During the grand jury proceeding, the Commonwealth presented evidence of the following. On the night of January 28, 2022, the defendant O'Keefe had a group of friends went to the Waterfall Bar and Grill in Canton, where the defendant consumed several alcoholic beverages. Shortly after midnight on January 29, 2022, she drove O'Keefe to the home of Boston Police Officer Brian Albert, where a group of people from the bar were meeting. Early in the morning on January 29, 2022, a heavy snow was falling with blizzard-like conditions. At 4:53 a.m., O'Keefe's niece called Jennifer McCabe. A friend of O'Keefe, and told her that she needed to talk to the defendant. What? That's not even right. That's not even right. Jennifer McCabe had been at the bar with the defendant and O'Keefe the night before and went to the Albert residence afterwards. The defendant was distraught because O'Keefe had not yet come home and was not answering his cell phone. Jennifer McCabe heard defendant screaming, "John didn't come home. We had a fight. I left him at the waterfall." Grand jury transcript would be noted for the remainder is GRT. And then they're citing this at around 5 a.m., the defendant called Carrie Roberts, whose husband is friends with O'Keefe. The defendant was hysterical, and she screamed, "John's dead," and then hung up. What? She called Roberts back and told her that O'Keefe had not come home during their conversation. She started, just so you guys know, there was 14 days of testimony from the grand jury, 40 witnesses, and 56 exhibits. She called back. "Something must have happened to him. What if he's dead? What if a plow hit him?" The defendant also stated, in quotes, "I don't remember anything from last night. We drank so much, I don't remember anything." The defendant, McCabe, and Roberts went to look for O'Keefe together at the Albert residence. While on their way there, the defendant wondered out loud whether she could have hit O'Keefe with her car and mentioned she had a crack in her taillight. Shortly after 6 a.m. on January 29, 2022, they arrived at the Albert residence, where the defendant spotted O'Keefe lying in the front yard covered in snow and unresponsive. When the paramedics arrived and asked what happened, the defendant, who was hysterical and inconsolable, repeatedly stated, "I hit him. I hit him." Again, that's going to be from the grand jury. Or no, that's going to be from somebody testifying at the grand jury. The paramedics transported O'Keefe to the hospital, where he was pronounced dead. The medical examiner ruled the cause of death as blunt impact injuries. So this is important. At the head and hypothermia. She did not see any obvious signs of altercation or a fight. During the subsequent police investigation, officers discovered pieces of a taillight and a broken cocktail glass at the scene. They seized the defendant's vehicle, which had a shattered rear taillight and scratches on the bumper. A forensic toxicologist opined that the defendant's blood alcohol level, now this is going to be interesting because this was her blood alcohol level, they said, at this time. The police officer spoke with people who were present at the Alberts residence, who all reported that they did not see O'Keefe and he never entered the residence. The Norfolk Advocates of Children interviewed O'Keefe's niece and nephew who lived with him. They say that the defendant O'Keefe argued frequently. They both described a recent argument within 2 weeks of Keefe's death that she needed to leave. I think you guys have already heard that part. So officers also recovered text messages exchanged between the defendant and O'Keefe on January 28, 2022, and voicemails. The defendant left O'Keefe on January 29, 2022, after 1 a.m. Leading up to the night at the waterfall, the defendant and O'Keefe exchanged several text messages about their strained relationship. So they're together and they're texting each other. In the voicemails that the defendant left O'Keefe on January 29, 2022, she stated in quotes, "You are effing using me right now. You are effing another girl. You are a effing loser. F yourself." She called him a effing pervert and she yelled at him, "John, I effing hate you." Ooh, okay, legal standard. So that's the background. This is what good old Deb thinks about the case. This is what she put. If you go and you look at what Judge has said about, the Idaho 4 case, you want to read what he believes the background is. So I wanted to see, this is Bev, okay? This is Bev's background, okay? Now the legal standard to get this dismissed. A defendant may be entitled to dismissal of an indictment if the integrity of the grand jury was impaired by a prosecutor's improper conduct in the introduction of certain evidence. Commonwealth v. Brown. The heavy burden to show impairment of the grand jury proceeding is borne by the defendant, so it's on, Reed's team to show this. The defendant must establish that 1, the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Number 2, the evidence was presented for the purpose of obtaining an indictment. And 3, the evidence probably influenced the grand jury's decision to indict. In certain instances, the failure to disclose known information may impair the grand jury proceedings. That's Mayfield. Prosecutors are not required in every instance to reveal all exculpatory evidence to a grand jury. Again, citing cases. However, they must present exculpatory evidence that would greatly undermine either the credibility of an important witness or evidence likely to affect the grand jury's decision, as well as evidence that withholding of which would cause the presumption or presentation to be seriously tainted. Now, let's see. If the defendant can show that the prosecutor omitted such exculpatory evidence and that the evidence withheld would likely have affected the grand jury's decision to indict, dismissal is warranted. Because there is no satisfactory or comprehensive statement of what conduct does and what conduct does not impair the integrity of the grand jury process, the court must deal with the conduct in question case by case. So this is a case by case, discretion. As noted above, now this is the discussion of it. As noted above, the defendant maintains that the Commonwealth knowingly and recklessly prevented false and deceptive evidence to the grand jury and withheld exculpatory evidence for the purpose of obtaining the indictments or the indictment. All right. So here we go. Number 1. This has to do with Sergeant Michael Lank's false and deceptive statements and conflict of interest. So this is their argument. The defendant argues that Canton Police Sergeant, so he was one of the first arriving officers. Okay. He's one of 3. Okay, I have one of those. What's up, Boston? I see you, girl. I see you, girl. Okay. Now. Oh, let's see. Gave false intel. Okay, yeah, here we go. Specifically, the defendant contends that the Commonwealth and Sergeant Lank, 1, gave false and deceptive testimony to the grand jury regarding purported admissions made by the defendant. 2, gave deceptive testimony as the reason the state police took over the investigation from the Canton police. And 3, withheld exculpatory information as to Sergeant Lank's longstanding relationship with members of the Albert family. Okay. Now, let's see what big old Bev says about this. The defendant's statements at the scene. With respect to the first argument, Sergeant Lank testified to the grand jury. So officers that were there prior to my arrival had attempted to speak with Reed. But from what I had gathered from them, so it's not his own, this is from them, she was too hysterical and was unable to really assist us in any way. The only information they were able to retrieve from her is that she could not recall whether or not she had been there. The defendant, so this would be hearsay. And let me tell you what, you're allowed to testify to hearsay if you've had 5 or more years experience. Like, you have to meet qualifications to be able to testify to hearsay for the grand jury. Or I'm sorry, at a preliminary hearing, actually. So with the grand jury, I want to double check that. But that's all hearsay. Let's like not kid ourselves here. He wasn't there. This is what he gathered from his, like, he didn't, this isn't him. The defendant contends that this testimony impaired the grand jury proceedings because it was not based on personal observations. Oh, ding, ding, ding. Distorted the defendant's statements to the responding officers and strongly suggested an admission of guilt. After careful review, the court concludes that this testimony does not meet the standard for dismissal. Who else testified? Like, to establish that the Commonwealth impaired the integrity of the grand jury, the defendant must first demonstrate the false or deceptive evidence was given to the grand jury knowingly or with reckless disregard of the truth. Nothing before the court suggests that Sergeant Lank gave knowingly false testimony to the grand jury or that the Commonwealth sought to deceive the grand jury with the presentation of his testimony. I don't know why they would be focusing in on. I'm going to look at my Excel spreadsheet because I don't know why. I don't know why he would be like the main focus of being talked about for this dismissal. Anyways, in certain instances, the failure to disclose known information may impair the grand jury proceedings. Again, this is just, she's citing certain things. Oh, wait. Wrong. That's where we go. Sergeant Lank clearly stated in his knowledge of the defendant on the morning of January 29, 2022 came from what he had gathered. Yeah, that's what I'm saying. Like, from other officers who spoke with Reed, not his. But he has a reason to say that that's what he had heard because of his relationship. I don't understand why they would even let him testify to that. Indictment may be based on hearsay so long as the hearsay testimony is not used to deceive the grand jurors. Moreover, although, okay, there's your case law. This is where you can use this hearsay. There you go. Moreover, although other evidence presented to the grand jury demonstrates that the officers on the scene obtained more information from the defendant than stated by Sergeant Lank, nothing before the court demonstrates that those other officers communicated that information to Sergeant Lank, or that he purportedly withheld it from the grand jury. Wait, what? Where did he get what he gathered from? Who did he get that from? God? I disagree with that. Inaccurate statements made in good faith do not require dismissal. Okay. Even if Sergeant Lank knowingly or recklessly gave a false statement to the grand jury, the defendant has not established that the Commonwealth presented Sergeant Lank's testimony for the purpose of obtaining the indictment. What the fuck are you talking about? Why else would they present it? Is she fucking on crack? What would be the purpose of having somebody testify to? You having people testify to establish what? In order to get the indictment. Otherwise, they wouldn't be testifying. That it probably influenced the grand jury's decision to indict. Prior to Sergeant Lank's testimony, the 3 officers who were first on the scene testified before the grand jury as to their firsthand observations of the defendant and statements she made. Canton Police Officer Stephen Sheriff describes the defendant as very, very distraught, very upset. She kept loudly and hysterically saying, "This is my fault, and I can't believe this happened." Just like somebody in the Riley strain, like that would be like his roommate saying, "Oh my God, this is all my fault. If I just would have walked back home with him." You know, that doesn't mean that he killed Riley. The fuck? Like, oh, it's all my fault. I should have never left without having him in my car. Interesting. Wild. So why have him testify if you have all these other firsthand accounts? What was the purpose of Lank's testifying? Canton Police Officer, okay. Canton Police Officer Stephen Mullaney described the defendant as hysterical and distraught and repeatedly screaming, "Is he dead? And that's my boyfriend." Canton Police Officer Sean Good described the defendant as hysterical, continually yelling, "Is he dead?" Okay, Officer Good asked the defendant how O'Keefe ended up outside the residence, and she stated, "I don't know." Okay. He asked if she drove O'Keefe there the night before, and she stated, "I think so, and then I can't remember." He stopped asking her questions because she was too upset and she was unable to keep a train of thought. Given the preceding testimony of these 3 officers, it is highly unlikely that the Commonwealth sought to deceive the grand jurors into thinking the only information officers could gather from the defendant was that she did not remember whether she had been to Albert's residence. For the same reason, it is equally unlikely that Sergeant Lank's testimony made a difference in the grand jury's decision to indict the defendant. Well, I would love to see the questions, Bev, because why the fuck would you have him? I want to see the grand jury. Which we probably never see, but okay. Why would you call him to the stand then? State police involvement in investigation. So that was number 1. Now, number 2 is the state's police. The defendant also argues that Sergeant Lank gave deceptive testimony as to the reason the state police took over the investigation from the Canton Police Department. Specifically, the defendant contends that Sergeant Lank's testimony that the state police assumed jurisdiction and took over the investigation as soon as it was determined that O'Keefe was deceased was an effort to conceal the fact that the Canton police lost jurisdiction in the case because their agency was conflicted. This is why he testified. The defendant has not shown that Sergeant Lank's testimony in this regard was false or deceptive. What? Or that he withheld exculpatory evidence. His testimony as to the reason the state police took over the investigation is consistent with GLC 38-4, which requires that the Norfolk County District Attorney's Office and its law enforcement representative here, the state police detective unit, direct and control an investigation of death that occurred under the circumstances presented by this case. The district attorney or his law enforcement representative shall direct and control the investigation of the death and shall coordinate the investigation with the office of the chief medical examiner and the police department within those jurisdictions. This is what, again, this is Bev. This is how Bev is seeing things, which is very, very important. The defendant has not put forth any evidence that suggests The defendant refers only to a Boston Globe article where a Norfolk County District Attorney, Michael, is quoted as saying the Canton Police Department recognized a potential conflict early on and recused itself from the case. This article is neither competent evidence the court can rely upon for purposes of this motion, nor does it lead to the conclusion that Sergeant Lank falsely testified that the state police took over the investigation once it was determined O'Keefe was deceased. Moreover, because the state police directed and controlled the investigation and the Canton police officers testified only to their involvement when O'Keefe's body was first discovered, it is unlikely that the grand jurors had known the Canton police had a conflict in connection with the investigation. It would have had any impact on their decision to indict. So she thinks that the grand jurors it wouldn't have mattered if you told me that the Canton police had to be, they couldn't be in charge of this because there was a conflict. I would want to know what that conflict is. I'd have questions, and that's what grand jurors can do. They can ask questions. I would have questions from that, and I want to know why. But she believes that, no, like even if so, how relationship with the Alberts. So here we go. The defendant contends that the Commonwealth intentionally withheld exculpatory information that Sergeant Lank had a long-standing relationship with members of the Albert family and that he, in the past, deputized himself to, quote-unquote, shield the Alberts from criminal liability. Defendant's memorandum at 19. In support of this argument, the defendant cites a complaint filed in a civil action against Sergeant Lank regarding an incident that occurred in 2002 where Sergeant Lank, while off duty, allegedly physically assaulted two individuals and had one arrested after they had an altercation with Tim Albert, Brian Albert's brother. The case later settled. According to the defendant, the Commonwealth's failure to disclose this information impaired the integrity of the grand jury proceedings because had the grand jurors known of this incident, it would have undermined Sergeant Lank's credibility in this case. The court is not persuaded. So again, Beverly thinks that the court is not persuaded by this argument that this would matter at all. Even though for the past 20 years, Lank has protected this family. Yeah, and I thought it was Chris. Did she get that fucking wrong too? Where she says that? I thought it was Chris Albert. She didn't get the names right. Yeah, I thought that. The Commonwealth's obligation is to present exculpatory evidence that would greatly undermine either the credibility. So she's sticking with this greatly. That would greatly. The defendant has not directed this court to any case law that suggests allegations in a civil complaint from 20 years ago against one of the many police officers' preliminary involvement in investigation would be considered exculpatory evidence. Interesting. Bitch wants case law on that shit. Allegations from a civil lawsuit which not full adjudicated are not exculpatory. Informing the grand jury that the police informant had convictions for larceny and breaking and entering 6 years before the investigation into the defendant began would not have been undermining the credibility of evidence. Nor is there any evidence before the court that suggests Lank engaged in conduct during his brief involvement with the case that suggested he was not impartial. Interesting. Even if knowing that Sergeant Lank had a history of friendship with Brian Albert's brother may have colored the grand juror's view of his testimony, Sergeant Lank was one of many police officers who testified before the grand jury, and his role in the investigation was minimal. His entire testimony makes up only 27 pages of the grand jury transcripts. That's a stupid fucking statement to say. Which over 1,400 pages in length. That's if I'm coming with a bombshell, it doesn't matter. My statement could be fucking 3 pages. Given the extensive amount of other evidence against the defendant, it is unlikely that disclosure of the withheld information would have affected the grand jury's decision to indict. Okay. Why did the grand jury happen in June? I mean, fuck. This happened in January, at the end of January. So you have February, March, April, May. You have 5 months. It's kind of like the Idaho 4 case. That's it. There you go. Idaho 4. Same thing. Trooper Michael Proctor's false and deceptive statements and conflict of interest. The defendant argues that State Police Trooper Michael Proctor, the homicide investigator for the Norfolk County District Attorney's Office, who co-led the investigation into O'Keefe's death, gave false and deceptive testimony to the grand jurors and failed to disclose that he had a personal relationship with other precipitant witnesses. Specifically, the defendant contends that the Commonwealth and Trooper Proctor withheld from the grand jury that Trooper Proctor is a close family friend of the Alberts. 2, failed to inform the grand jury that there was an alternate explanation of the defendant's broken taillight. And 3, withheld from the grand jury that the death certificate stated the manner of death could not be determined. Relationship with the Alberts. With respect to the first argument, the defendant has proffered evidence that shows Trooper Proctor's sister was friends with Jennifer McCabe and Julie and Chris Albert, the brother and sister-in-law of Brian Albert. Even assuming that Trooper Proctor had a personal relationship with these witnesses, disclosure to the grand jury was not necessarily required. Only when the prosecutor possesses evidence which would greatly undermine the credibility of evidence likely to afford the grand juror's decision to indict must he alert the grand juror to existence of such evidence. So she's just saying that they did not have to do it. Wow. The defendant has not pointed to any case law that suggests a police officer's credibility is greatly undermined if he knows witnesses in a case. Even if Trooper Proctor's familiarity with the witnesses suggests some sort of bias, and the investigation that the grand jurors may have considered to warrant dismissal, the defendant must show that the absence of the withheld evidence likely would have affected the grand juror's decision to indict. The grand jury heard extensive evidence supporting probable cause to believe the defendant struck O'Keefe with her vehicle. Therefore, even if the grand juror had been aware of Trooper Proctor's relationship with the Alberts, it, quote unquote, would almost certainly have left unaltered the disposition to indict. I want to know if they were specific about all the different dates that they got the evidence from the taillight. We got this on this day. We got this on this day. We got this on this day. Like, did they disclose that? Did they disclose all the fucking dates? Alternate explanation for the broken taillight. Turning to the second argument, Trooper Proctor testified that the state police viewed footage from ring cameras at O'Keefe's residence, including one camera located above the garage doors. So they didn't show the ring camera to the fucking grand jury because he's testifying to it, so that they show it. The Commonwealth showed the grand jury the video, okay, and Trooper Proctor testified as to what he saw. He stated that at 5:07 a.m. on January 29, 2022, the defendant is seen reversing out of the garage and driving off. As she backed out of the garage, her right rear taillight came extremely close to Mr. O'Keefe's SUV. No pieces of taillight were viewed anywhere in the driveway that day, and no damage was observed. Okay. In Cliff Notes, we got to read this. Citing Sergeant Bukaki's testimony, the defendant also argues that the Commonwealth intentionally misled the grand jurors as to Trooper Proctor's relationship with Chris and Julie Albert. Sergeant Bukaki read to the grand jury his report of the interview he conducted with Trooper Proctor of Chris and Julie Albert. The report began with the words, "Following formal introductions." The court does not agree that this testimony was intentionally misleading. Sergeant Bukaki wrote the report, and there is no suggestion that he knew either of the witnesses or used this language to misrepresent Trooper Proctor's connection to Chris and Julie Albert. Well, what did he use the language for? The court also does not agree with the defendant's argument in her supplemental memorandum that the Commonwealth withheld evidence of Sergeant Bukaki's pre-existing relationship with another witness, Brian Higgins, because Sergeant Bukaki and Higgins had drinks, socialized at the gym, and had worked on a couple of cases together. Defendant's supplemental memorandum at 9. For the same reasons, the court has concluded that Trooper Proctor's aligned pre-existing relationship with some witnesses does not warrant dismissal of the indictment. It concludes Sergeant Bukaki's familiarity with Higgins does not warrant dismissal. Going back to the SUV, the defendant argues that the testimony was misleading because her vehicle did strike the SUV, breaking her taillight, thus providing an alternative explanation to the Commonwealth's theory that the taillight broke when the vehicle struck O'Keefe. Nothing about, now this is her, this is how Bev sees it. Dude, this is wild. This is Bev, baby. This is how Bev views that video. Nothing about Trooper Proctor's testimony was misleading. Because she says it was just his opinion. Wait, this is great. The Commonwealth was not obligated to offer an ulterior explanation for the broken taillight. The Commonwealth is not required to present evidence of so-called defenses or otherwise disprove such matters before the grand jury. Nor does the fact that the defendant has a different interpretation of the video make Trooper Proctor's testimony false or misleading. He just simply viewed it differently. I don't think it hit that car. You think it hits, but I still to this day don't think it hits. So therefore, I'm not misleading you. These are my observations. God damn, man. But do you see how she's explaining this for them? Nor does the fact the defendant has ever. Moreover, the ring video was introduced into evidence before the grand jury, allowing the grand jurors to assess whether the defendant's vehicle made contact with O'Keefe's SUV. I will give her that. See Grand Jury Exhibit 44. Accordingly, there is no merit to the defendant's argument that Trooper Proctor's testimony about the ring video impaired the integrity of the grand jury process. Well, what speed did they play it at? Did the grand jurors have the opportunity to play it at close, or, did they have a chance to say, okay, play it at half the speed? O'Keefe's death certificate. Let's get on to that. The defendant lastly contends that the Commonwealth attempted to deceive the grand jury with its presentation of evidence regarding O'Keefe's death certificate. During the proceeding, Trooper Proctor testified that the cause of death listed on the death certificate was blunt impact injuries of head and hypothermia. He was not asked, and therefore did not testify that the death certificate listed the manner of death as could not be determined. See Grand Jury Exhibit 41. He was not asked that question. During the proceeding, Trooper testified that the cause of death listed on the death certificate was blunt impact injuries of head and hypothermia. He was not asked, and therefore did not testify that the death certificate listed the manner of death as could not be determined. Damn. So that's why it's go ahead and look at the exhibits. So according to the defendant, like Odell, the Commonwealth distorted the evidence by only presenting a portion of the information from the death certificate. This argument, too, is unavailing. The circumstances here are markedly different from Odell. In Odell, police detective read the grand jury an edited version of the defendant's statement to police in the aftermath of armed robbery. As edited, the statement suggests an admission of guilt by silence when, in fact, the defendant had disclaimed any knowledge of the robbery to police. The Supreme Judicial Court held that the admission of part of the defendant's statement was not a mere withholding of exculpatory evidence, but tended to distort the meaning of the portion of the defendant's statement that was repeated to the grand jury. Here, unlike Odell, omitting the manner of death could not be determined did not tend to distort the meaning of the cause of death. Indeed, this information sheds no light on the cause of death. Wow. This woman has the backs of her peeps. Moreover, because the death certificate was submitted to the grand jury as an exhibit, see Exhibit 41. Wait, I thought 41 was a different exhibit. So it was 41. So 41's the death certificate. The medical examiner's conclusion as the manner of death was not concealed by the Commonwealth. Accordingly, Trooper Proctor's testimony as to the death certificate did not distort the presentation of the evidence to the grand jury. It was like, no, bitches, you just need to look up for yourself. Interesting. Wow. Chris and Julie Albert's inconsistent statements. The defendant next challenges the testimony given by Chris and Julie Albert. She argues that Chris Albert gave inconsistent statements regarding his presence at the Albert residence after the waterfall, and Julie Albert changed her story as to how she found out O'Keefe has died, and that the Commonwealth withheld both inconsistent statements from the grand jury. The court does not agree. The court notes that it is more likely that the Commonwealth did not elect testimony about the manner of death because generally it is impermissible as evidence. Nothing contained in the record of death which has reference to the question of liability for causing the death shall be admissible in evidence. Commonwealth v. Ellis. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. And then here, before the grand jury, Chris and Julie Albert testified that they were at the waterfall the night of January 28, 2022, but that neither went back to the Albert residence afterwards. Julie went home early with a headache, and Chris walked home when everyone left the bar. Sergeant Bukaki testified as to his interview with Chris and Julie Albert on February 10, 2022, where both made similar statements. The defendant contends that Sergeant Bukaki's February 21st, 2022 report memorializes his interview of the witnesses, indicated that Julie and Chris Albert did go back to the Albert residence after the waterfall, and that the Commonwealth intentionally failed to elect Chris Albert's inconsistent statements before the grand jury. Defendant's memorandum at 24. Given that Chris Albert testified consistently with Sergeant Bukaki's February 10th, 2022 report that he was read to the grand jury, it does not appear to the court that he did, in fact, given an inconsistent statement. The error appears to lie in Sergeant Bukaki's later report. She is just repeating what Lally is saying. That's exactly what Lally said in his oral argument. Electing the inconsistency in Sergeant Bukaki's report would not likely have affected the grand juror's decision to indict. Accordingly, dismissal is not warranted based on this argument. Nor is it dismissal warranted based on the defendant's argument that the Commonwealth failed to impeach Julie Albert with her prior inconsistent statement regarding how she found out about O'Keefe's death. Julie Albert testified before the grand jury that on the morning of January 29, 2022, she woke up at 5:50 a.m. and saw she had a missed call from Jen McCabe. She didn't think, obviously, anything bad, got out of bed, changed her clothes, and headed over to the Albert residence to drop off a gift for her nephew's birthday. Who the fuck does it at 5:50 in the morning? See the grand jury testimony. Upon arriving at the Albert residence, she learned of O'Keefe's death. Sergeant Bukaki read his report memorializing his interview with Julie Albert on February 10th, 2022, in which she gave a different account of the morning. She told Sergeant Bukaki that she was asleep at 4:55 a.m. on January 29, 2022, when her phone woke her up and there was Jen's missed call, and that is how she found out about O'Keefe dying. The court does not agree with the defendant that the Commonwealth's failure to impeach Julie Albert warrants a dismissal. First, the Commonwealth did not withhold Julie Albert's inconsistent testimony from the grand jury. Contrast Odell. Both her testimony and the statement she gave Sergeant Bukaki were before the grand jury. It is therefore not the case that the Commonwealth carefully scripted the testimony in order to hide the ball on the grand jury regarding Julie Albert's inconsistent statements. Are these grand jurors idiots? Because if what she is saying is accurate, then who was on the grand jury? I mean, a bunch of idiots? See Commonwealth v. Hunt. Prosecutor presented witnesses' identification of defendant but omitted witnesses' prior statements that she could not identify the perpetrators. Yeah, I mean, if both of them. Moreover, even assuming Julie Albert falsely recounted how she found out about O'Keefe's death, listen to this. This is hilarious. Woo, baby, look at you. Get on with your bad self. What? Moreover, even assuming Julie Albert falsely recounted how she found out about O'Keefe's death during her grand jury testimony, the defendant must show not only that the evidence was material to the question of probable cause, but on the entire grand jury record, The false or deceptive testimony probably would have affected the decision to indict. Well, yes, because she knew about the death before they found the body. How is that not material? Material. Bev, what the fuck are you talking? See, this is a what the fuck moment because Bev, I can see what you're doing here with the other stuff. Okay, great. But this right here, the defendant must show not only that the evidence was material, if she was to know about something at 4:55, 5:50, they hadn't. Karen Reed, they're not to the body yet. Like, so how does Julie Albert know that John O'Keefe is dead before they arrive at the body that morning? So how this would not be considered, I don't know, bombshell? How the grand jury would not say to themselves, wait a second, because nobody in the grand jury, because they're idiots, said to themselves, wait a second, if Julie Albert knew at 4:55 or even 5:50 that O'Keefe is dead, Karen Reed isn't even to the body yet. What? Come again? How does Julie Albert know this? Why does Julie Albert think this? There's a big, I mean, that's, like I said, I don't know who's on this grand jury, but I'm a bunch of woohoo. So the court does not agree with the defendant's assertion that the difference in testimony clearly inculpates Julie Albert and exculpates Miss Reed. Defendant's memorandum at 26. It is more than an inferential leap to conclude, as the defendant does, that Julie Albert's statement to Sergeant McConkey suggests that she and Jennifer McCabe knew O'Keefe was dead before his body was discovered that morning. How is that a fucking leap? That is called logic and reasoning. If you know something before I know something, then I couldn't have been the one to possibly tell you about it because you knew before I knew, right? So then who told you? How would you know this material? If I'm supposed to be the first one to find out about something because I arrived to a body at 6 o'clock, well, but that person knew before me, but I was supposed to be the first person that found his body. So how would you know this before? What are you talking about? A leap? But I mean, that this is biased right here. The rest I can get around because I can see how she did it. You know what I mean? But this right here, this isn't a leap. The court does not agree with the defendant's assertion that the difference in testimony clearly inculpates Julie Albert and exculpates Miss Reed. I don't even like the way that's worded. I wouldn't say that. It's a known fact before Miss Reed can possibly know that fact. How does Julie know about this? Do they have fucking ESP? Do they have ESPN? This is all crazy right there. Highlighting the discrepancy in Julie Albert's testimony would not likely have undermined the value of other evidence tending to show that the defendant committed the crime. Interesting. Thank you for that. Now, introduction of we're gonna round it out here with time of Jennifer McCabe's Google search. In her supplemental memorandum, the defendant argues that the Commonwealth intentionally and recklessly deceived the grand jury by presenting an incomplete extraction of Jennifer McCabe's cell phone as an exhibit before the grand jury. See defendant's supplemental memorandum at 13. According to the defendant, this grand jury exhibit number 49 purposely left off a Google search Jennifer McCabe made at 2:27 a.m. before O'Keefe's body was discovered, stating "House long to die in cold." The defendant has not shown that the Commonwealth improperly withheld this evidence. They have. What are you fucking talking about? The grand jury exhibit referred to by the defendant is a Cellbrite cell phone extraction report from Jennifer McCabe's cell phone containing the call log, contacts, instant messaging, and tags in her cell phone. A more recent Cellbrite report obtained during the federal investigation provides the web history of the phone, including the aforementioned Google search at 2:27 a.m. and a search for how long to die at 6:27. There is no evidence that the more recent report was available to the Commonwealth at the time of the grand jury proceedings. Indeed, based on an examination of the two reports, it appears that the more recent report used an updated version of software, which included web history, data files, and activity sensor data that the previous software did not extract. Because the Commonwealth could not have withheld information it did not have and was not aware existed at the time of the grand jury, the defendant has not established that the Commonwealth withheld exculpatory evidence from the grand jury for the purpose of obtaining the indictment. Okay. We're going to pick this back up because I want to pick up right though back on 18, 15, there was 20, 19, 18, 17, 22. This is where it gets a little juicier. Basically, guys, Bev is right in the term of saying that they didn't have that information, so they couldn't have withheld something that they did not have. But can it be said that they just didn't go and get that information versus that they didn't have it? They just chose not to go get it. Is there a difference? Don't know. Don't know if it was available. Don't know if that version, I can't imagine that. I mean, I know Excel Cellbrite dumps that I have currently in my possession from 2020 most certainly have all these Google searches that were deleted. So if you can do it in 2020, the software was capable. So it's not that the Commonwealth didn't have it. It's that they didn't go and get it. It's that they were told not to go and get Google searches. You get what I'm saying? But then again, how do you prove that? I guess you can just prove that it was available to like that. They're going to get rocked in court because the best part about it is that Bev is not the jury. Okay, Bev is not on the jury. That's one positive thing. She cannot be called to be on this fucking jury. Awesome. Because but I'm saying when you want to talk about decisions and you want to talk about they're going to be at a huge disadvantage. We're going to continue this because we're going to get to the juicier part of it. But Bev makes the decisions to, overrule, sustain, she makes a lot of calls, and they're not going to go Karen Reed's way. You have to know that. You have to understand that. And so preserve the record as best you can, knowing that you're not going to, and I think that was where the strategic part came in and why they did not file and supplement anything. They said, fuck this. We're not showing our hand. We're not going to show our hand. And that's where I think the strategic part came in and why they didn't supplement things and why that last hearing kind of was like a flop. It's because they said, oh, fuck no. We're strategically not going to play our hands with things because we don't want to give them a heads up. That's what I'm thinking. But it sucks that you have a biased judge. I do believe that Karen Reed has a biased judge, but I do believe that Karen Reed has the better attorneys in Alan Jackson. But guys, whoever was on that grand jury, I mean, a bunch of tards. That's all I have to say about it. And hopefully they do a really good job with voir dire and to make sure that the jurors on this trial that's happening in just a couple weeks aren't fucking idiots. Period. Yeah, that's what I believe, and they didn't want to show some of their hand. So with that said, join me for our next hour. See you soon. Peace. Peace.